The Supreme Court decision in the case of Raul DOMEN versus People of the Philippines. At the outset, the court takes judicial notice of DOJ Circular No. 18 dated May 10, 2022, which expressly revoked DOJ Circular No. 027 dated June 26, 2018. The recent circular aligned its provisions with the court-issued plea bargaining framework in drugs cases. Consequently, we deem the prosecution's objection to Raul's plea bargain in criminal case number 2017-24487 as effectively withdrawn. The recent circular aligned its provisions with the court-issued plea bargaining framework in drugs cases. Consequently, we deem the prosecution's objection to Raul's plea bargain in criminal case number 2017-24487 as effectively withdrawn. In People v. Monteiro, the court laid down the following guidelines to be observed in plea bargaining in drugs cases. 1. Offers for plea bargaining must be initiated in writing by way of a formal written motion filed by the accused in court. 2. The lesser offense which the accused proposes to plead guilty to must necessarily be included in the offense charged. 3. Upon receipt of the proposal for plea bargaining that is compliant with the provisions of the plea bargaining framework in drugs cases, the judge shall order that a drug dependency assessment be administered. If the accused admits drug use or denies it, but is found positive after a drug dependency test, then she shall undergo treatment and rehabilitation for a period of not less than 6 months. Said period shall be credited to his/her penalty and the period of his/her aftercare and follow-up program if the penalty is still unserved. If the accused is found negative for drug use/dependency, then he/she will be released on time served. Otherwise, he/she will serve as her sentence in jail minus the counseling period at rehabilitation center. 4. As a rule, plea bargaining requires the mutual agreement of the parties and remains subject to the approval of the court. Regardless of the mutual agreement of the parties, the acceptance of the offer to plead guilty to a lesser offense is not demandable by the accused as a matter of right, but as a matter addressed entirely to the sound discretion of the court. Though the prosecution and the defense may agree to enter into a plea bargain, it does not follow that the courts will automatically approve the proposal. Judges must still exercise sound discretion in granting or denying plea bargaining, taking into account the relevant circumstances, including the character of the accused. 5. The court shall not allow plea bargaining if the objection to the plea bargaining is valid and supported by evidence to the effect that the offender is a recidivist, habitual offender, known in the community as a drug addict and a troublemaker, has undergone rehabilitation but had a relapse, or has been charged many times, or when the evidence of guilt is strong. 6. Plea bargaining in drugs cases shall not be allowed when the proposed plea bargain does not conform to the court-issued plea bargaining framework in drugs cases. 7. Judges may overrule the objection of the prosecution if it is based solely on the ground that the accused plea bargaining proposal is inconsistent with the acceptable plea bargain under any internal rules or guidelines of the DOJ, though in accordance with the plea bargaining framework issued by the court, if any. 8. If the prosecution objects to the accused plea bargaining proposal due to the circumstances enumerated in item number 5, the trial court is mandated to hear the prosecution's objection and rule on the merits thereof. If the trial court finds the objection meritorious, it shall order the continuation of the criminal proceedings. 9. If an accused applies for probation and offense is punishable under Republic Act No. 9165, other than for illegal drug trafficking or pushing under Section 5 in relation to Section 24 thereof, then the law on probation shall apply. Here, the state ascribes grave abuse of discretion on the part of the RDC when it approved Raul's plea bargain despite the objection of the prosecution on the ground that DOJ Circular No. 027 prohibits plea bargaining for illegal sale of dangerous drugs under Section 5 to the lesser offense of illegal possession of drug paraphernalia under Section 12 of Republic Act No. 9165.